Hai, Assalamualaikum warahmatullahi wabarakatuh. We are from Group 2, which will present about examine the problem in the implementation of hudud in Malaysia. So, before we go through the topic, let me introduce our group members. Firstly, myself, Nur Farah Akilah binti Semeran. Second, Nurul Afika binti Hashim. Third, Nur Akilah binti Shahrizal. And the last is Nurhana Izati binti Nur Azlan. So, here we go. Alright, for this introduction, hudud is one of contents in Islamic criminal law other than qisas and ta'zir. Okay, each of it has its own special law and properties. The meaning of hudud is based on excerpt from the book Mengenal Kanun Jenayah Islam written by Dr. Abdul Ghani Azmi bin Idris that derive from the plural. The singular is haddun. According to language, it means limit or restraint. Okay, the gatekeeper was named Haddad, and this law is called hudud on the ukubah of immorality because it can usually prevent the perpetrator of immorality from repeating the act of immorality, which is therefore subject to limits. And originally, the word's limit was something that separate between two things, which is it was used over something that distinguishes something from another. Okay, according to the terms of Shara, hudud is ukubah, which means worldly punishment, which has been prescribed to protect the right of Allah Subhanahu wa Ta'ala. Therefore, it does not include ta'zir because ta'zir has no provision for punishment, and also it does not include qisas because qisas is the right of children of Adam. Okay, the offense of hudud crime is considered an offense against the right of Allah because the act affects the interest of the general public. Does it affect the peace and safety of the people, and the punishment is good for them. So, through this topic, we will learn about the type of hudud offenses, how the implementation of hudud is done, what's among the problems that have occurred, and more. Okay, so let's hear an agreement from the next presenter.
Assalamualaikum warahmatullahi wabarakatuh, and a very good day to everyone. My name is Nurhana Izati binti Nur Azlan, and today I will be presenting our group's objectives. For this section, I will be providing particular objectives for this topic on problems in the implementation of hudud in Malaysia, which is the topic that we had researched and did for this presentation. So today's study's key goals will be as follows: to study about hudud law and its sectors, to identify the hudud crime and punishment sentence to respective crimes, and to study the discourse and challenges in implementing hudud in Malaysia. In summary, all these will be the objectives that we would like to reach from the presentation that we'll be doing after this. Thank you.
Hello, Assalamualaikum. My name is Nur Akilah binti Shahrizal. So today I would like to present about issue of implementation of hudud bill in Malaysia. The first one is hudud law is not fair if it is implemented in Malaysia. This does not mean that hudud law itself is unfair. As we know, the law based on the revelation of Allah is all perfect and benefit for all people. What is not fair in this discussion is that the implementation of hudud law is only for Muslims. which means that only Malaysians who are Muslim will be subject to hudud punishment if they are involved in a criminal offence. If hudud law is applied in Malaysia, it means that there are two different type of law. In fact, in Malaysia we have two laws, namely Syariah and civil law. But with the existence of hudud law in the legislation, it will be unjust in the administration of punishment. This is because hudud law is under Sharia law, and law under Sharia law can only be applied to Muslim. For example, Muslim who commit adultery for a married person will be stoned, while non-Muslim who commit adultery may be fined or not fined at all. This problem will be more complicated when the zina partner is a Muslim and the partner is not a Muslim. The non-Muslim couple may not be severely punished, while the Muslim couple will be stoned to death if the offender is married. Here the problem will arise when there is no common basic of punishment. The second one is hudud and the supremacy of the federal constitution. The Constitution, as well all know, is the supreme law of Malaysia. According to Article 4 of the Federal Constitution, this Constitution is the supreme law of the Federation, and any law enacted after Merdeka Day that is inconsistent with the Constitution is invalid to extent of such inconsistency. This is because affected by British colonizers. As a result, the Federation of Malaysia of Malaya was governed by Western law and equality principle. In the item 1 state that the Sharia court has no jurisdiction in respect of offence except to the extent provided by federal law. States have legislative power over Islamic matter listed in item 1 of the state list, which among other things include the power to make Islamic law and personal and family law of Muslim like case of marriage, divorce, and so on. But the law related to crime is under the federal constitution, like stealing, killing, and this punishment is not under the jurisdiction of Sharia court. And the Sharia court with jurisdiction over Muslim only. Then, as everyone can see on the slide, this punishment is Act 1984 is power of the Sharia Court provided by the Constitution of Malaysia 1897 which can punish with imprisonment or fine to the Muslim only. Punishment in Sharia law which are 3 years imprisonment, the fine not higher than 5,000 fine and wiping in excess of 6 lashes. This punishment are enacted by Parliament. The third is hudud is for past political propaganda. The propaganda is the candidate widely employed propaganda technique to manipulate the public mind in the political world. It same goes situation to Pakatan Harapan and past parties. Other political figure and the public state that the implementation of hudud law that past political want to put forward only want to get the attention and vote of the supported only. Tun Dr. Mahathir Mohamad, former Prime Minister, said that one UMNO of the consequence of supporting past agenda to implement hudud punishment in Kelantan. And he also said that the Islamic penal code was being introduced for political purpose. Therefore, the issues become a political controversy. The community also feel skeptical that this was done to uphold the religion or to use only the name of the religion. The last one is the lack of understanding of hudud bill among Malaysians, especially to non-Muslim. Malaysian society does not fully understand the implementation of hudud punishment itself. Based on the investigation in article titled Acceptance of Multicultural Society on the Hudud Bill implementation in Malaysia, from by that responded believe that the Hudud Bill implementation is excessive. They will think that if someone steals the goods, the thief will have his hand cut off. Many people misunderstand and state that this hudud punishment is a cruel punishment, but in fact, it is actually a fair punishment. In conclusion, there are many issues related to the implementation of hudud punishment in Malaysia. The effort to implementation of hudud face the challenging of the legal system regarding the limited jurisdiction of the Sharia court in implementing hudud punishment. Then the view of Muslim and non-Muslim on the implementation of hudud law also play an important role in the implementation of hudud punishment. This is because Malaysia is a democracy country. The political controversy related to hudud punishment can also have a negative impact on society. Especially for non-Muslim, because society think that the implementation of this law is not for the benefit of the people but only for political interest.
Assalamualaikum, my name is Nurul Afika and I will present the hudud criminal and punishment. Hudud crimes are comprised of 7 categories of offences. Firstly is adultery. According to Mazhab Syafi'i, adultery is sexual intercourse between a man and a woman, which is forbidden for him, particularly because there is no marriage contract or Syubhah contract and is aware that the action is haram. An adultery who meets the criteria of muhsan, including a Muslim, san, reach the age of puberty, then is subjected to the muhsan adultery penalty, which is stoned to death. If a person commits adultery and not a muhsan, he will be punished with 100 lashes. The ulama accept that the penalty for adulterer who has repented will fall as long as he did not report it to the court. Thus, the previous action is placed in the matter of Allah subhanahu wa ta'ala. Secondly, accuse someone of adultery or QAZAF. It is a particular crime involving a serious accusation of adultery towards a decent and holy individual or deny his innocence, and the accusation cannot be proved by 4 witnesses. The original sentences will withdraw if there would be any uncertainty regarding the evidence. Those who falsely accuse women of adultery that are innocent and decent will be sentenced by being whipped 80 times. The adultery accusations are made between men and men, woman and woman, and man and woman. Thirdly, consuming alcohol, which is an intoxicant liquor, whether a small or large amount, drunk or not, where it can affect mental sanity. Muslim will be punished for whom consuming alcohol will be whipped 40 times. For action commit 3 times, he will receive a punishment of 80 lashes. If the crime continues, in other words, if the person who consumes is addicted, the scholar conclude that the penalty that should be applied is punishment of beheading. But only the imam, who is the leader of the state, has the authority to define this penalty. Fourth is thief or SARIQAH, which described as an act of illegally transferring movable property from its master without his master consent. Jumhur ulama, including Imam Syafi'i and Imam Malik, conclude that the punishment are divided into 5 parts. Thief that steals for the first time is subjected to cut the right hand to the wrist. Stealing for the second time is subjected to cut the left leg to the ankle. For the third time, stealing will be subjected to cut left hand to the wrist. Thieves who stole the fourth time are subjected to cut right leg to the ankle, and stealing for the fifth time will be sentenced to taze or imprisonment until he repents. Scholars have also argued about the return of stolen property. According to Imam Shafi'i and Imam Ahmad, the stolen property must be returned to the owner. But amputation of hands and the return of the property are two penalties that will be applied at the same time. The punishment amputation of a hand is taken out is because of the violation of God's rights, while returning stolen product is for violating human rights. Next is apostate, an individual who abandons Islam religion, whether by faith, word, or action. Apostasy is punishable with the death penalty, according to the law of apostasy. Various jurisprudence mention the death penalty as a mandatory requirement. For example, according to Imam Shafi'i, apostates are required to repent for 3 days. If the offense continue declining to repent, he should be executed. The death penalty for apostasy is enforced not because of the apostasy itself, but because of the insult to Islam that has existed since apostasy. As a result, apostate who disrespect Islam should be punished. The sixth step is robbery or HIRABAH, where an individual or group attempt to use violence to take property, murder, or threaten another person. The HIRABAH criminal is divided into 4 categories, which are the action of threatening or harassing a person without seizing or killing them, the action of confiscating the property only, the action of killing the victim only, and the action of seizing the property and killing the victim. The individual who commits HIRABAH will be sentenced with Hudud punishment, which is firstly sentenced to death and then crucified if the victim of the offense is murdered and their property or the property of another person under his responsibility is stolen. Will be sentenced to death only if the victim of the offense is murdered but the property is not taken. Third, will be punished with amputation of his right hand and left leg if only the property is taken without murdered or injured the victim. But if the victim is murdered with the property is taken, then diyah shall be taken. And lastly, will be prison decided by the court which not exceeding 5 years if the only threat is used but not taking any property or causing death. Lastly is a traitor or bukat, where is a term used to describe a group of Muslims who criticize or refuse to obey the government that enforce the Sharia and Islamic law. The Al-Quran and Hadith source clearly mention the death penalty for those who oppose a just government. The offender must be made aware of his guilt and be warned of the danger or bad consequences for being a traitor. If he does not want to repent and does not want to return to Islam, then the death penalty shall be imposed on him. The implication of Hudud implementation. A criminal act, according to Islam, is an offense that should be punished, whether it violates the right of Allah subhanahu wa ta'ala or human rights or both. The objective of Sharia will be preserved by implementing Hudud. There are 5 principles of Maqasid Sharia: the glory of religion, life, intellect, property, and lineage are all valued in Islam. Any violation of these 5 principles represent a criminal offense must be punished. Hudud also result in the prevention of violent crime and safeguarding the environment. To prevent individuals from committing crimes, a punishment is established. Therefore, offender must be sentenced to make sure the community is secure. It also enhances educational development. The enforcement of the severe penalty of hudud to the criminals should take place in front of a group of people. The criminal penalty also serves to educate and prevent others from committing such crimes, as well as to protect society from injustice.
So, in conclusion, as we know, modern scholars such as Al-Zuhaili, which is in fiqh al-Islam wa adilatuhu, clearly state that the question of the implementation of Islamic criminal law in modern times is a considerable challenge, as it involves the process of taqnin, or write legal text referred to in the traditional language barrel in the Quran and Hadith into modern legal language. Thus, he tends to state that no modern country is the best example and benchmark on the implementation of such law because they are local in nature. Okay, the method of implementation depends a lot on the demographic factor of the country, such as economic background, foreign intervention, the political strength of local leader implementing Islam, the influence of non-Muslim, and more. Okay, completely, the reality of every Islamic country today is very different. Okay, in conclusion, there is a lot of debate about the implementation of Sharia law in the modern country. Most of them are academic in nature, so there should be as much space as possible for open debate among scholars, politicians, authorities, and the court. To be sure, the true attitude of Muslims is that they must believe in the necessity and beauty of the implementation of Sharia law in their respective countries, as well as refrain from giving criticism that is insulting to the law of the sky. Moreover, simplistic thinking should be avoided when enthusiastically implementing this law. Instead, it should be analytical in nature so that its implementation is not purely textual without ignoring the current contextual. So, I think that's all from our group. Thank you for your attention. Sekian, wabillahi taufik wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.